and welcome to ConstangyTV's Close-Up on Workplace Law, where we zoom in on recent developments of interest to employers, to their lawyers, and to their human resources professionals. I'm Leigh Tyson, and I'm a partner in Constangy's Atlanta office. So this summer, new federal rules on sex discrimination in the workplace took effect, and although the new rules only apply to companies that do business with the government, so federal contractors, the issue of sex discrimination and the evolving definition of sex discrimination is obviously a topic of great interest and great concern to all employers. And there are a lot of changes happening, so here to talk to us today about all of the changing sex discrimination scene is Cara Crotty from our Columbia, South Carolina office. Cara is the head of our Affirmative Action Practice Group, and she advises employers on affirmative action and compliance with all of the rules that are issued by the Office of Federal Contract Compliance Programs, or the OFCCP. Cara also defends employers who are involved in OFCCP audits and discrimination lawsuits, and she is a frequent writer and a blogger. And we are very excited to have her here today. So Cara, welcome.
Thank you, Leigh.
So Cara, hasn't sex discrimination always been illegal? That's what I've been telling my clients. How do these new federal guidelines change anything?
Sure. Obviously, sex discrimination has been unlawful since Title VII of the Civil Rights Act was passed back in 1964. But with this administration's intense focus on the wage gap between men and women, federal agencies as well as state governments are becoming more aggressive in trying to find ways to close that gap and in some instances expand coverage of existing laws. So recently, we've seen a lot of changes such as the executive order and regulations on pay transparency for federal contractors, which prohibit them from punishing employees who talk about compensation. President Obama amended Executive Order 11246 to extend the non-discrimination protections to individuals on the basis of sexual orientation and gender identity. The EEOC has sought to expand the pregnancy accommodation requirements. And also the OFCCP issued new and updated regulations on sex discrimination. So they replace their outdated existing guidance and in some instances advance more expansive interpretations of existing law.
And so can you give us some examples of something that didn't used to be discriminatory but is now considered discriminatory?
Sure. The most obvious example are protections for LGBT individuals. So the OFCCP regulations provide protection for individuals on the basis of transgender status. So the regulations specifically provide that contractors must allow transgender individuals to use the bathroom and other facilities of the gender with which they identify. They also provide that blanket exclusions for transition-related medical procedures are likely to be considered discriminatory. And then the OFCCP sex discrimination rule also prohibits sex stereotyping. So that means that treating individuals differently based on sexual orientation may be unlawful if it's based on sex stereotypes, such as a man appearing effeminate or a woman displaying masculine characteristics.
And everybody right now obviously is very interested in the rights of lesbian, gay, bisexual, and transgender employees. The federal government's position used to be that Title VII didn't offer them any protection, but that has changed quite a lot, hasn't it?
Absolutely. As I mentioned, federal contractors are now prohibited from discriminating on the basis of sexual orientation and gender identity based on the executive order that President Obama issued. And then the OFCCP sex discrimination regs also specifically cover gender identity. But further than that, the EEOC contends that the prohibition against sex stereotyping under Title VII applies to many LGBT individuals. So, and of course, we can't forget all the various state and local laws that offer LGBT protections.
Moving on to pregnancy, the United States Supreme Court came out with a decision in 2015 and said that employers may actually have to accommodate pregnancy and its related conditions. So is that a new requirement for employers?
Well, many states and cities were already requiring pregnancy accommodations, but the United States Supreme Court decision in Young versus UPS held that generally employers must provide accommodations to pregnant employees on the same basis that they provide accommodations to other workers who are similar in their ability or inability to work.
So basically, before you weren't allowed to discriminate against somebody because they were pregnant. You couldn't treat them worse because they were pregnant. But now employers may actually have to do something, may actually have to take some affirmative action to accommodate their pregnancy?
In many instances, yes. For example, if an employer offers light duty to an individual who's been injured on the job under workers' compensation, then they're likely going to be very wise to provide light duty or some similar accommodation to a pregnant worker who is similar in their ability or inability to work and needs such an accommodation.
Probably would be a good idea under the new decision. Okay, well, let's talk a little bit about pay transparency. What does that mean exactly?
Well, the president issued an executive order, and of course, OFCCP followed that with regulations that prohibit employers from punishing employees or applicants who talk or ask about compensation. There is an exception for employees who have access to compensation information as part of their job. But generally, employees and applicants are allowed to discuss that. And the rationale behind the rule is that employees who are free to discuss compensation issues with their coworkers are more likely to discover potential pay disparities, which again goes back to eliminating the wage gap.
So many employers used to have rules saying that you couldn't discuss your wages. Obviously, we have a little problem with that over in our practice group because the National Labor Relations Act basically prohibits that kind of rule. But now are those rules going to be completely a thing of the past?
Right. Well, they really should be. Like you say, it's considered protected concerted activity, and we have generally advised employers to abandon those type of policies. And obviously, for federal contractors, they also have the additional obligation of posting the pay transparency statement in the workplace. So that type of policy would not be applicable to them. Yes.
And then, of course, also many states have their laws on pay equity, and they may offer even more protection than the federal laws too, right?
Absolutely. Pay equity is such a hot political topic right now. Employers definitely need to be aware of the laws in all the locations where they have operations. California and Massachusetts provide two recent examples of pretty expansive pay equity laws.
Cara, thank you so much for joining us today.
Thank you, Leigh. It was my pleasure.
Okay, and that is it for this edition of Close Up on Workplace Law. If you have any opinions or comments or questions or even ideas for any more shows, please send us an email at ConstangyTV@constangy.com. And thank you so much for tuning in. We look forward to seeing you next time. Bye-bye.